Bismillahirrahmanirrahim. Assalamualaikum warahmatullahi wabarakatuh. My name is Muhammad Hazizi Bezokanain from DPM5A and my metric number is DPM2233 Okay, today I will doing the business law final project. So I choose the situation about explain the procedures of repossession. The explanation should include on how the procedure may protect the hire. Okay, firstly, I want talk about the introduction of the hire purchase or repossession. Okay, the Malaysian Hire Purchase Act 1967 provides several remedies to the owner of goods laid out on the hire purchase in case of a breach of the hire purchase agreement by the hire. Repossession of the hire purchase good is one of such remedies. Repossession occurs when the hire has default in the payment of installment. In reality, repossession of the hire purchase goods strikes at a core feature of a hire purchase transaction. It denies the hire the possession of the hire purchase goods. Therefore, the remedy of repossession is not likely administered. Repossession entails the good, instead of being the custody of the hire, finding their way back to the owner. Upon repossession of the goods by the owner at once has possession of an property in the goods. From the perspective of the hire, upon the owner repossessing the goods, the hire loses his position and the use of the hire purchase good. Since the paper focuses on the remedy of repossession, which is available to the owner of goods under the Malaysian Hire Purchase Act, it is important to point repossession of hire purchase goods. The third part deal with the concept of repossession of goods under the Hire Purchase Act. Under the part, the paper will address the safeguards that have been put in place both before and after deposition in order to protect the interest of the hire. This part of the paper will also address some of the weakness of the Act, especially in terms of protecting the interest of the owner. The Act seems to be overprotective of the hire compared to the owner. The fourth part focuses on the conclusion. This part will embrace some recommendation bearing in mind that a hire purchase form of agreement greatly appeal to a hire because he is given possession of the good as well as a period of time to pay by regular installment. Therefore, a balanced approach is needed in order to protect the interests of both parties when the owner exercises his right to repossess the goods. Next, I will discuss about the procedures of the repossession. Firstly, I want to talk about the before repossession. Okay, let's start. Before repossession, Section 16(1) requires the owner to supply the hire with a notice of repossession. In other words, notice of repossession must be given to the hire when goods are to be repossessed. Before the owner exercises his right to repossess the goods, the owner must first assure that the balance of the loan to be paid by the hire must be more than 1/3 of the purchase price of the goods hired. By fulfilling this requirement, only then the owner would have complied with the requirement that the hire has default to successive installment. Under Section 16(1), the owner must serve the hire a 21-day notice of intention to repossess in writing as set out in the fourth schedule. The written notice must be serviced in compliance with Section 43 of the Act. The owner can retake possession of the goods only after the expiry of the notice period and if the overdue installment are not settled by then. In Peng Brother Motor Sendirian Berhad versus Lee Ai Seng, where a car was taken by respondent on hire purchase agreement with the appellant. The respondent failed to pay the installment. Do the appellant issue a notice under Section 16(1)? The issue was whether the notice was in fact served. The court held that Section 16 clearly specifies that the period before which the seizure can 16 to make sense, because hires who have default in their monthly installment have been known to disappear and to remove the good or conceal them in order to prevent the owner from repossessing them. Under Section 16(7), it is provided that before the owner or his agent repossesses the goods, he must, in addition to complying with the provision of the Act, comply with any regulation as may be prescribed under the Hire Purchase Regulation 1976. Rule 3.1 requires the owner to send a notice to the hire informing him that the owner intends to repossess the goods. A copy of his notice must be sent to the controller of hire purchase. This notice is in addition to the notice contained in the fourth schedule. Section 16A provides that a hire who returns the good comprised in a hire purchase agreement within 21 days after the service on him of the notice in the form set out in the fourth schedule shall not be liable to pay the cost of repossession, the cost incidental to taking possession, and the cost of storage. However, it is important to note that open service of the notice under the fourth schedule and after 21 days had lapsed from the service of the notice, the owner may take possession of the goods. Secondly, is after the repossession. Okay, within 21 days after repossessing the goods, the owner is required the Section 16(3) to serve on the hire and every guarantor of the hire a notice in the form set out in the fifth schedule. Section 16(3) is mandatory, and if the owner fails to comply with this section, the right of the owner under the hire purchase agreement will cease and or terminated. This is clearly spelled under Section 16(6) of the Act. Therefore, it is important for the owner to serve a notice in the form as set out in the fifth schedule on the hire and every guarantor of the hire within 21 days after the owner has taken possession of the goods. In Hong Leong Finance Berhad versus Rajendran, Augustine Paul J. stressed the importance for the owner to comply strictly with provision regarding notices as set out in the fourth and fifth schedules. The owner is also required under Section 16(4) to deliver to the hire a document acknowledging receipt of the goods. The document must set out a short description of the goods, the date, time and place where the goods were repossessed. This is by virtue of Section 16(5). As mentioned earlier, if the owner fails to serve the notice in the form set out in the fifth schedule, his rights under the hire purchase agreement they open, cease and determined. This is by virtue of Section 16(6). But the owner may apply to court immediately for an extension of time as contained in Section 41 of the Act. Such an application should not be done as parts, because it is equally important to note that the net amount payable for purposes of Section 18 is the total amount payable less statutory rebates for terms charged and insurance. The value of goods is the best obtainable price or the cash paid by the person introduced by the hire, less reasonable cost of repossession, including storage, repair and maintenance charge, and reasonable cost of selling or attempting to sell or otherwise dispose of the goods. This is by virtue of Section 18.3a and b of the Hire Purchase Act 1967. Under Section 18.4a, it is provided that where the owner intends to sell the goods by public auction, he must serve on the hire a copy of the notice of such public auction not less than 14 days from the date the said auction is to be held. Therefore, when the owner takes possession of goods and required to sell them by public auction, he is responsible to ensure that the goods are sold at the best market price. If the owner fails to comply with such requirement, the hire will be stopped from reducing his losses. This was unenunciated by Yusuf Muhammad J. in the case of Hong Leong Finance Berhad versus Lee Ching Heng. In addition, Section 18.4b ensures the sentiment that if the owner intends to sell the goods otherwise than by public auction, he must give the hire an option to purchase the goods at the price which he intends to sell if the price is less than the owner estimate of the value of the goods repossessed. If the owner fails to comply with this requirement, he shall be guilty of an offence. Under Section 18.5a, the hire will not be able to recover anything from the owner unless he acts fast. He must, within 21 days of receiving the notice under the 5th schedule, give to the owner a notice in writing setting out the amount which he is claiming under this section. The notice can either be signed by the hire himself or by his solicitor or agent. On the other hand, Section 18.5b states that after sending the notice to the owner, the hire must then commence action in court not later than 3 months after the notice had been sent to the owner. If before proceedings under Section 18.5 comments by the hire, the owner serve on the hire and offer in writing to pay the amount claimed, the matter would be settled if the offer is accepted by the hire. If proceeding commenced, the owner may pay the amount offered into court, and in this event, he is entitled to the same right as if he had tendered the amount to the hire. This is by virtue of Section 18.6 of the Hire Purchase Act 1967. In other words, at any time before proceeding against the owner have been commenced by the hire, the owner can make an offer in writing to the same force and effect in relation to the right and liabilities of the owner and the hire as it would have had if the notice had been duly given. Thus, it is hereby recommended that Section 16.6 of the Act should be amended in order to remove the kind of imbalance in the scale of justice as far as hire purchase transactions are concerned. Okay, after that, I will discuss about the rights and protections of the hire purchase or possession. In the course of purchasing the goods, a purchaser that will become a hire upon completion of the hire purchase agreement will deal with a dealer or seller. There would be a case where a dealer or seller commits the act of misrepresentation towards a purchaser. For instance, give wrong information as to the year the goods was manufactured with the intention to deceive a purchaser, because he, a dealer or seller, knows that a purchaser may not interested to buy the car if he knows that the car manufactured in certain particular year. In this, circumstance, a hire is entitled to claim from the owner or any person making misrepresentation in the course of purchasing or negotiation that's leading to the hire purchase agreement. A hire may sue the dealer or seller or their agent as well as the owner for damage and rescind the hire purchase agreement. However, since the dealer or seller is regarded as the agent of the owner, the latter may claim an indemnification from the dealer or seller. The rights and protection of hires according to the Hire Purchase Act will be available once the hire purchase agreement has been concluded in accordance with the requirements imposed by the Hire Purchase Act. Those rights and protection are derived from the implied condition and warranties that are given to the goods hired. On the other hand, as far as the right and protection for the owner is concerned, it will be related to right to repossess the goods hired once the hire default in making scheduled payment. The implied condition and warranties that are applied for the goods hired to the hire are similar to the implied condition and warranties that are offered to the goods that are sold according to the Sale of Goods Act 1957. As to implied conditions in hire purchase agreements, there are three implied conditions where the owner has the right to sell the goods at the time when the property is to pass. The goods hire must be of merchantable quality and the goods hire must be fit for the hire's purpose. There is no definition of merchantable quality available in the Hire Purchase Act 1967. Thus, the meaning of merchantable quality as provided in the Sale of Goods Act 1957 shall be referred to. Merchantable quality means the goods are fit for particular use to which the said goods were sold. Thus, if the goods is of no quality and defective, it can be considered as of no merchantable quality. Whereby, as to implied condition, that the goods hired must be fit for hire's purpose. It does not applicable to the hire if he purchased the second-hand goods and were exclusion of the implied conditions warranties as to fitness is expressly spelled out in this agreement. It seems that when the goods is of no merchantable quality, it may not be fit for hire purchase as well. On the other hand, there are two implied warranties available in the hire purchase agreement that include the right or hire to enjoy quiet possession of the goods, and the goods hired should be free from any charge or encumbrances created by the owner in favour of any third party. Quiet possession means there shall be no interference by the seller as to enable the hire to enjoy the goods or any interference arising from lawful acts of the third party. Alright, last but not least, I will talk about the conclusion of the repossession or the hire purchase act. It is evident from the above discussions that the owner has the right to repossession of the hire purchase goods if the hire commits a breach of his obligations under the hire purchase agreement. Usually non-payment of installments. The governing statute on hire purchase in Malaysia has been around for some time, though it captures of the important remedy of repossession that the owner can exercise in a hire purchase transaction. There are gaps to fill in its provision regarding the enforcement of this all-important remedy available to damnified owner. There is no doubt, however, that the provision of the Act seem to be overprotective of the hires. For example, the consequence of non-compliance with Section 16.3 by the owner tends to create an imbalance in the scale of justice in hire purchase agreements. This is by virtue of Section 16.6, which imposes a penalty on the owner who failed to serve a Section 63 notice. The right of the owner under the hire purchase agreement would cease and determine. It would seem that the owner would not able to enforce any remedy given to him by the agreement to recover any amount from the hire. Thank you. That's all from me.